Hello everyone. Today I'm gonna talk about the contract. Contract have 7 sections. First, it is offer, second acceptance, then consideration, then quasi-contract and promissory estoppel, and reality of the consent, and next one is capacity, and the last one illegality. Let's talk about the offer. Offer have 3 elements. First, present intent to contract, which means that you have to be present to make an offer. Define terms, which mean there could be specific terms in a contract like I will sell you my car for $500. That sounds like an offer and it is defined terms. Third one, communicated to offeree, that you actually communicated to offeree. Acceptance have 3 elements. They pretty much the same. First, present intent to accept, which means that you've been there to accept an offer. It should be the same terms. Mirror image rule apply over here. It's like looking at the mirror, you see the same picture. The same should be in the contracts. When you accept, that you accept on the same terms. Communicated with offeree, that when you accept, you actually communicated to offeree. The silence without more, it's not an acceptance. If you didn't say anything, that's mean that you did not accept, because silence without more is not an acceptance. Under acceptance, there is a mailbox rule, which is very important to know. The mailbox rule have 3 elements. First, mail reasonable means of acceptance. That means if the offer was made in the first case via mail, then it is reasonable to actually reply on that offer and accept it via mail. It should be properly addressed and dispatched, delivered to post office. The third element, acceptance, is effective on dispatch. That means no matter when it will be delivered, it is effective when you put it to the mailbox. For example, you have insurance and it says you should pay your bill on your insurance, let's say until Monday. So you went to post office, you put your mail on Friday. So it takes usually a couple days to get there, and let's say your mail arrived to insurance company on Tuesday, and they say, well, you didn't pay on Monday, so we should cancel your insurance. That's not true. Acceptance is effective on dispatch. That means if you put it to the mailbox, to the post office before Monday, it doesn't matter when it's going to be delivered, it is effective when you actually drop it. Let's talk about the merchant. Merchant is under acceptance. Merchant, that means if both parties in business, there is a 3 elements of the merchant. It is assurance that offer. Second, will remain open for specific time, and it should be in signed writing. There is also another thing which called battle of the forms. Battle of the forms, if the offer was eliminated or new terms, materially significant difference, or the offeree objective additional terms. If one of these elements will met, that means that the contract could not be formed. Exception for mirror rule. In this case, if you both merchant, that means that the mirror rule will not apply to you or could not apply to you, that you could accept it, because if you both merchant, you could actually change the contract with additional terms. Another two important things. You can revoke until acceptance unless it is a merchant that you're in the business of offer, or you can not revoke if you are merchant and your offer has been officially signed. Consideration. What is it, consideration? Consideration is what do you get out of the deal. It has three elements. First, legal value. That means property, money, service. Second, bargain for, make a deal. Third one, flows both ways. Consideration could only count one time. If it's count more than one time, then it means it's a past consideration and the contract could not be formed. In consideration, there is also some elements like nominal consideration, which means a little, is not consideration unless it is something more. For example, you're trying to sell your land for $1. It is nominal consideration because the land actually costs more than $1, so the value of that should be more, otherwise it is a gift. Illusionary promise. It does look like a promise, but it's not. For example, you say to your friends, okay, I will drive you to airport at 3 a.m. in the morning if I will feel like it. What do you think? Of course, you cannot rely on that person because it doesn't seem like that person made a promise. It more seems like suggestion, or you can call it illusionary promise. And another thing which I would like to mention, ad is not an offer. Let's talk about the quasi-contract. Quasi-contract, it is not a contract. Usually it's used by plaintiff if the person would like to get some benefits, something from the deal, which did not been made via the contract, because in the first case that person didn't enter into the contract, or there was no acceptance, or there was no offer, or there was no consideration. So the quasi-contract have three elements. First, it's benefit conferred. That means that it was beneficial for you and you got something, then not only accepted, you knew that this is going on. And the last element, it is not fair to keep without paying. For example, you decided to paint your house, so you hire some people, but they did mistake to paint your neighbor's house. In that case, your neighbors were out of town, been driving by, and they knew you were supposed to paint your house, so they left, and when they got back, they got new paint house. And in that case, the person who was painting the house could go for quasi-contract. He did not have actually the contract with neighbors, he had the contract with you, but it is not fair to keep without paying. So he have to prove all the elements, that it was beneficial for your neighbors, that they knew that this is going on, and then it's not fair to not pay him. Now we're gonna talk about the promissory estoppel. Promissory estoppel have four elements. First, it is a promise Then, second, promiser intended to induce reliance. That means you kind of was relied on an action that could be beneficial for you. Third, promisee reasonably relied. That means if someone made you promise, you was thinking that you can rely on that person because you had some sort of relationship with that person. Economic detriment. That means that you lost something or you got damaged because that promise did not happen. The fifth section talks about reality of the concept. It consists of the four elements. First, fraud or misrepresentation. Second, mistake. Third one, duress. And last one, undue influence. Let's talk about misrepresentation and fraud. It has four elements. First, untrue assertion of fact, which means someone lied to you when you was making a deal. Second, fact was a material. It was quite valuable that it changed the whole deal. Third, relied on the fact that you relied on that fact. And four, reliance was reasonable. It was reasonable to rely on that fact because you trust that person. Plaintiff need to prove all of these elements and defendant just need to kill one. Second one, mistake. Mistake could be unilateral mistake. That means that one party just made a mistake, or bilateral, which means both parties made a mistake. Innocent mean when you didn't know about that mistake. And fraudulent, which means you knew about it and you kind of cover that mistake in case you hope that it will not show up. Third one is duress. Duress, it's a threat. And it also means that overcomes free will. If someone points to you a gun and say, sign it or I will kill you, or something like that, that means it's a threat. And you sign that deal under a threat, which is do not have a legal value because it was a duress. That person cannot sue you because we had a contract, you accepted, yes, you accepted under duress, which doesn't have a legal value. It's happened quite rarely, but it is important to know. And the last one, undue influence. Usually section 5 used by defendant if that person would like to get out from the contract because there was either fraud, misrepresentation, or mistake, or duress, or undue influence. Let's talk about the undue influence, the fourth element of the reality of the consent. Undue influence have two elements. First, it's relationship of trust and confidence or dominance, which mean that you kind of knew about the person who had vulnerable, who had some weaknesses, and it was in your best interest to actually provide that service or to make that person sign that contract. And second, it is unfair persuasion, which means that if you are signing the contract, you've been in a rush or someone put you in a location where you don't feel yourself comfortable, that's unfair persuasion. Let's talk about the section 6 of the contracts. Section 6 talks about capacity. What is it, capacity? Capacity, it is ability to have legal value to enter to the contract. Capacity includes three elements. First, minors. whose legal terms are often seen as infants. Who is the minors? Minors, it's usually children who don't have a right to enter to the contract. The law trying to protect the minors, so that's why it is included in a capacity. Second, mental challenges. The people who have mental diseases who cannot think clearly. And third one, intoxicated. That's mean if you sign with someone a contract who was drunk or who did not understand what's going on, that person actually could disappear from the contract. Disappear means ability to get out from the contract. So if you are minor or either have mental challenges or you've been intoxicated, you have the ability to disappear from the contract. Also, there is an exception for minors. If it's necessary for minors, essential to continue existence and do not provide by parents, like you buying clothes for your children, that's you intend to the contract, the parents do not provide it, so it is necessary for existence. It's the things which minors cannot exist without. There is also could be a case like if you sign up the contract with a minor and the minor one day decided to disappear because the minor have that power, you can go to the quasi-contract. For example, you're renting your apartment to a minor because that minor doesn't have a place where to stay or where to live. That minor pay you a certain amount of money and one day he or she decided do not pay and disappear from the contract and keep living there. So what could you do? You can go to the quasi-contract. Quasi-contract, as we remember, have three elements. It is beneficial for a minor, right? It is, because you're providing a place where the minor could stay. Knowingly accepted. The minor knowingly accepted, and it's not fair to live there without paying. Nothing is for free. So there should be a reasonable value of payment. In that case, the minor should pay reasonable value of payment if it's this case gonna go to the court. Let's talk about the last section of the contract, which is illegality. Illegality has three elements. First, it is violate the statute. A contract that violates the statute illegal. For example, I will pay you if you will kill that person. It is illegal to kill someone, so it is violate the statute. Second, violate public policy. Policy that protect the public. If the contract violates public policy, you cannot enter to the contract that violate that policy. For example, you working in a restaurant and there is rats. So you tell your manager, hey, we have rats, we kind of need to call the inspection, and your manager say, I will pay you if you're gonna keep it quiet. Well, you take the money, you didn't say anything. It is kind of violate the policy because the restaurant should provide their safe environment to eat. The third element is unconscionable. Unconscionable, that means that something shake your mind, that it was so unfair, that you were feeling so unconscionable. Unconscionable have two sub-elements. The first, contract of adhesion, which means one party has more bargaining power than another. Second, terms favor stronger party. And third one, take it or leave it. no power to negotiate. The majority of their companies, like which selling their product or providing a certain service, they have the contract of adhesion. You do not have a power to negotiate. You come to T-Mobile to get a new SIM card and you sign the contract, and you don't have a power to negotiate, and one party have more bargaining power. The T-Mobile have more bargaining power than you do, and the terms favor stronger party, so they got paid the amount which they asking from you. Second, it's unconscionable sub-point. There is 2 points. First, must be both procedurally not fair. For example, you lock someone in a room and says, sign the new contract or I will fire you. That's not fair. And substantively, which means one of the terms of the contract was not fair.